I appreciate your laying that out, and I'll just let me dig into two cases, if I can, that I think are also probative here, because I agree with the wide range of supporters we've heard from that you've demonstrated an even and impartial judicial approach in your record. But this is true not just in the hundreds of sort of run-of-the-mill quotidian cases that are considered by a district court judge, but in several that have been highly charged and really quite political in terms of their consequences. I'd like to discuss your opinion in the Center for Biological Diversity versus McAleenan. Do you recall that case?
I do, Senator.
It was a dispute between groups advocating for environmental protection and the Trump administration's Department of Homeland Security. The dispute was about President Trump's efforts to quickly construct a physical border wall between the United States and Mexico. I'm sure I don't need to remind you or anyone here that at the time, Democrats were just about unanimous in thinking that physically building a wall from coast to coast was not the wisest use of resources to secure the border. There were other ways to do it, and with Republicans pretty much unanimously willing to defend it. So it was a policy matter with some sharp divisions and some political consequences. You ultimately ruled in favor of the construction of the wall and against an attempt by environmental groups to halt its construction through a legal case. Can you discuss what you recall just briefly of the claims presented and how you came to a decision in favor of the Trump administration?
Senator, the claims in that case, which, as you say, were brought by an environmental organization, related to the Administrative Procedures Act, which is something that we often see in the District of Columbia, and whether or not the agency could waive certain environmental laws pertaining to the construction of the wall, whether or not the agency's determination to do so was lawful. And I looked at the relevant circumstances, and I ended up, I believe, dismissing that case on threshold grounds before getting to that point in the analysis. But consistent with what you said, I was guided by my understanding of the law and what it required, and not by anything else.
I could spend a lot of time on the details of this case, but let me try and summarize it this way. You analyzed the statute. You concluded Congress had clearly blocked the courts from hearing non-constitutional challenges. There was no jurisdictional bar to the constitutional claims. To decide them, you considered whether the plaintiff's claims were viable. You looked for precedent. You found one. While not controlling, you thought it was legally sound and persuasive. But there was no controlling circuit court or Supreme Court precedent that stopped you. If you were in fact an activist judge, a motivated partisan determined to let these plaintiff environmental groups proceed, you certainly could have. There was no clear precedent that barred that from happening. You analyzed the statute. You applied the best precedent you could find, and you reached a result without regard to the political consequences.
That is correct, Senator.
So in my view, I wanted to talk about this case because there's really nothing unusual or special about it from your perspective.
That is correct.
For those of us up here, there was a lot special and important about it. It was a highly charged partisan and political issue, but you looked at the statute, you found persuasive precedent, you applied it, you went on to the next case.